Right. One moment, folks. We'll be live on all platforms. Just wait for Facebook to go. All right. So we are live on Facebook, Rumble, Twitter, Twitch, YouTube, and Telegram. And today we're going to be talking about Trump's first week in office and has equal employment opportunity been revoked? We're going to be digging deep into that subject a little bit based on one of Trump's recently signed executive orders. We'll also be covering some other issues, such as his release, his executive orders demanding the release of the RFK, JFK, and MLK assassination files, as well as many ICE deportations in the first 48 hours, I think it was, or like a bunch of them. News coverage on that. And then we'll go from there and we'll discuss it. So with that being said, let me share my screen and get us into the first part of this segment.
A Fox News exclusive. This is from Bill Melugin reporting on the ICE raids captured on video out in Boston. Let's show you that. Again, this is Bill Melugin with Fox News in this exclusive.
It's a frigid 5 degrees in the pre-dawn hours just outside of Boston, where this team of elite ICE officers is briefing on their targets for the day.
We're going to be targeting some extremely violent offenders today.
Within moments, the officers are on the move, with eyes on their first target.
Looks like we got movement, target vehicle coming out.
They quickly take him into custody. He's an MS-13 gang member wanted in El Salvador for aggravated murder. And he has an Interpol red notice out for his arrest.
We are targeting very violent threats to our community.
I'm not going back to Haiti.
One of those threats is this illegal alien from Haiti. ICE says he's a gang member with 17 criminal convictions in recent years.
Trump, you feel me? Yo, Biden forever, bro. Thank Obama for everything that he did for me, bro.
ICE Boston quickly takes down its next targets, including this illegal alien from Brazil who has an Interpol red notice for armed robbery. This Salvadoran illegal alien charged locally with rape and released by a sanctuary jurisdiction.
Señor, ¿cómo se llama?
And this Dominican illegal alien charged with assault with a deadly weapon and heroin trafficking. Officers also arrested this Guatemalan MS-13 gang member facing gun charges. ICE says he was released from local custody just the day before. Their detainer request was ignored because of sanctuary policies. And in a sign of shifting priorities with the new Trump administration, this man, who was in the same apartment as the target, was also arrested after ICE determined he's also in the U.S. illegally. This is what ICE calls collateral.
So you guys got your main target just now, but you got somebody else. What just happened?
So our main target was released by a sanctuary jurisdiction, not honoring a detainer. That person was released back into the community, and when we went to go find him, he's with somebody else who was previously removed from the United States. So he's going to go today too.
And that is exactly what Border Czar Tom Homan has warned would happen.
When we find the bad guy, he's probably with others that are in the United States illegally. They may not be a criminal priority, but we're not walking away from them.
ICE Boston says they will continue to go into sanctuary jurisdictions and do their job.
Today was a good day. Today we took several significant public safety threats out of our communities. Unfortunately, a lot were released by sanctuary policies, but we're here to tell the Commonwealth and the rest of the country that we're going to find them whether they're released or not.
Again, Fox News' Bill Melugin with that report there and that ride-along with elite agents with ICE out in Boston. And I do want to show you just some reaction from this reporting. Vice President J.D. Vance saying an illegal alien with 17 criminal convictions really hates President Trump for sending him back to Haiti. He's grateful to Biden for letting him come here. I'm glad we're deporting him. Do you agree, or would you like him as your neighbor there? So Vice President J.D.
Would you want to speak on that, what we just watched there, Robin, for a bit, for our viewers, and then I'll chime in?
Sure. I think the idea that we are inviting people into our country and and giving them whatever they need to survive, paying them good money, uh, uh, setting them up with a food stamp card for all their food stamps, setting up with hotels for all their so they have a place to stay. This was something that I never could understand. What are we doing? What are the American people benefit? What is the benefit to the American people of bringing people in that do not go through a vetting process, but just come across the border? Come one, come all. It's like at my 18th birthday party. I went to the high school where I went to high school, and I said, I'm having a party, and all my friends are invited. And all my friends said, well, what do you mean all your friends are invited? I said, all my friends. And they were like, well, is there a guest list? I said, all my friends are invited. Well, we had over 500 people come to the party. It was insane. There were motorcycle gangs there. There were
True story.
true story.
Oh wow, that's
And it
funny.
was, my parents ordered 10 pizzas, and those 10 pizzas vanished in about 10 seconds when they got to the kitchen. The delivery guy delivered them. We brought them into the kitchen, opened up the boxes, and I had about 2 slices of pizza, and everything was gone by the time I ate those 2 slices. Um, because there were so many people at the house. It was just outrageous. But a couple of people tried to pick a fight with me, and I said, "Well, look, if this guy comes up and says something to me, and his friend says, I don't think he likes you." And I said, "Well, then you probably really shouldn't have come to my party, should he?" And they kind of realized who they were talking to, and
Uh,
oh, yeah, and they backed off. But
that's funny.
it's but when you don't have any limitations,
Mhm.
can come to the party, then you wind up with all kinds of people.
That's a good
And
analogy though you made. I think that's a really good analogy. That's perfect.
some of them are going to be friendly, and some of them are likely not to be. And you've invited them, so it's not, you can't look at them and go, "Oh, shame on you, you came to the party," because they were invited. We just opened the door and said, "Everybody come in." But there are laws in this country that govern that, and those are immigration laws that were being violated by our own government's policies. And they still are with these sanctuary city laws and sanctuary state laws.
Well, I had no idea, like until recently when I was looking into this subject, that even if they commit crimes, they just get released back out into the community and they don't face any charges. I had no idea, but they don't enforce any pressing charges against violent offenders or anything like that. Like just throw them back into the communities because that's the policy. And I
Yeah,
had no idea that was policy. I thought for sure they had some sort of protections where they have to hold them accountable, but no, they just release them right back into the community. And I was like, whoa, that's not good.
I can't imagine that the majority of Americans even know about those policies, that that's really how it works. Because who would be for that? If we're going to throw a party at your house and we're going to say everyone's invited, and then if somebody comes to that party and starts picking fights, and there's blood and there's guts and there's fisticuffs, and you throw them out of the party, and then there's nobody saying don't come back, they just walk right back in and start more fights and cause more trouble. That's what we are in America. We've thrown this party for these people, and now we've just said, and oh, by the way, there are no rules. It's a ditty party. Do whatever you want to anybody you want, anytime you want. And will you get will you get in trouble for it? Well, you might get arrested, but they'll just let you go. Go do it again. Do it as many times as you want. Rape, murder, kill. It doesn't matter to us. Doesn't matter what the crime is. You're not going to be prosecuted. That is the policy.
Yeah.
of these sanctuary cities, this
Yeah.
sanctuary policy. And to me, that's just sheer insanity. And I believe that I'm illustrative of the average person. I think once the average person really understands that that's the policy, that it doesn't matter how violent an offender is, doesn't matter how horribly cruel any crime they've committed is, they're just let go and put back into society to go and kill again, to go and murder again, to go and rape again, to go and rob. And that's the policy. That's not a sane policy.
So
That's not a
they're not beholden to any law, any of the laws that we're held to. They're just given a free pass, basically.
right, right. You or I, if we commit those crimes, we face consequences. And when we go before a judge, the judge isn't going to say, "Oh well, just go do it again. You're free." That's not an American person policy. That's a sanctuary policy for illegals or those that are in the country illegally, um, that are from other countries. And if you're one of those people, well, good on you, mate. Go play. But if you're an ordinary human being, an ordinary American citizen who was born and raised here, with the kind of morals and and upraising that kind of makes that the kind of thing you would be very unlikely to engage in those kind of crimes, well, you're going to face consequences. And it's a dual standard
Yeah.
that absolutely violates the civil rights of all those that are not given those freedoms, but are subjected to those laws because others are given those freedoms and are not subjected to those laws. And that's insane. America has gone nuts. So I'm really grateful to see that we now have a president that looks at it from a more reasonable point of view, in my estimation, um, and is establishing policies that mean that these people aren't just able to continue committing crimes. The Lake and Riley law, I think, got signed into law very recently, and of course, those that know that Lake and Riley was killed by illegal aliens, by illegal immigrants, and those immigrants murdered her, and they wouldn't have been able to do that except that they had been let out on these sanctuary city laws, these sanctuary laws in our
So they
country.
weren't held or kept incarcerated, charged, or anything, and they were just let back go right back into the communities. And that's a travesty. Man, I had no idea it was like that until I started, like I said, until I started looking into it. And I mean, I just assumed, well, no, there's no way that they're gonna not hold people accountable that break the law, regardless of whether they're citizens or not. But no, I mean, when I looked into it, I was like, whoa, that's freaking troubling. You
Yeah,
know?
yeah. And I for one can't countenance that. I can't tolerate that. To me, that's not only un-American, it's inhuman. And we need to do a much better job of creating accountability for our politicians.
Yeah.
What politician signed this law? Which one? And if it was more than one, well, then I want the list of all of them, because I want to know who the criminals are that
Right.
set these policies up for these individual criminals to be let go and laid out in
Well,
front.
well, you heard that one guy. He thanked Biden and Obama.
Yeah, yeah. Kidding. Thank you, Biden. Thank you, Obama. Give my thanks to Mr. Obama, and that, and you know what, the other one.
Yeah. Man. Anyway, so let's. I want to segue into another executive order that Trump signed, releasing the JFK, RFK, and MLK assassination files. We're going to watch a video segment on that. It's about 7 minutes and 25 seconds long. A good little rundown on it, and then we're going to segue into another executive order here. We'll get to in a minute. after we talk about this one briefly.
Thousands of classified government documents about the 1963 assassination of President John F. Kennedy, which has fueled conspiracy.
Hold on. Sorry about that. Full screen wasn't functioning like it's supposed to. I don't know why my toolbar's here, but whatever.
President Trump has ordered the release of thousands of classified government documents about the 1963 assassination of President John F. Kennedy, which has fueled conspiracy theories for decades. We also know that he said he wants to declassify the remaining federal records relating to the assassinations of Senator Robert F. Kennedy and Reverend Martin Luther King Jr. The order is among a flurry of executive orders that Trump has quickly taken the first week of his second term. I want to discuss the situation as a whole and what happens next. So let's bring in Larry Sabato, director of University of Virginia Center for Politics and author of The Kennedy Half Century. Thank you so much for taking the time to be here with us today.
Certainly, Josh.
And it's Sabato. Sorry about that. What is the significance? What is the significance of this release overall?
Well, this is important because for decades we've been trying to get in to see these documents. And they've gradually been released, and in fact, millions of pages have been released over the years. This is a result of the JFK Records Act of 1992, which President George H.W. Bush signed in October of 92. But even then, the papers were supposed to be turned over by the CIA and the FBI and a lot of other alphabet groups. And there was an assassination documents review board set up under a federal judge. That took another 10 plus years, and everything was supposed to be released in 2017 during President Trump's first term. Well, there's a provision in that act that says if the CIA and the FBI and others believe that the release of this document and that document and the other document would be damaging to the nation's national security and so on, then they're allowed to advise the president not to do it. It's still up to the president. That has resulted in about 3,000 documents in whole or in part not being released. Well, this is no surprise. Some of those documents are probably among the most sensitive. I say probably because you can't know what's in there until you see them. So this has been a long road. It's 61 plus years since JFK was assassinated, and RFK and MLK were assassinated in 1968. Ever since the Warren Commission came out in 1964, there have been questions about how accurate it was, whether there were other shooters, whether there were conspiracies. I'm not sure there were, but I also know we can't know what we don't know. And we're not going to know everything until we see these documents. And probably the documents through the years have been destroyed. They were allowed to get rid of documents really between 1963 and 1992. What do you think if there were any incriminating documents? They might have been lost or they're not able to be retrieved. I don't want to be too cynical, but that's my guess.
And I have to ask here about the opposition overall. I mean, you touched on this, but what is the opposition to releasing these documents? As you mentioned, several of them, many of them have been released over time, but what is the opposition to releasing these documents altogether?
What I have been told over the years, and again, I have no way to verify this because I can't see the documents, but I've been told that potentially people who are mentioned in these documents could be subject to retaliation in some form or another. Say if there were spies that we had inside Cuba, for example, that releasing their names could result in damaging actions against even their descendants. Obviously, in those cases, you want those people protected. But I also need to note, it's been a long time. You know, I was 11 when JFK was assassinated. I'm in my 70s. Most of the people who are mentioned, probably the vast majority, not only are dead, they're long dead. So you're not going to be able to follow up on a lot of this, but also I think fewer people than ever would be at any threat at all. And when are we going to learn everything about it? Are we going to wait? As one key person told me when I was researching the Kennedy half century, he said, if you're going to bet on a year when we'll get everything, I would bet on 2063, the 100th anniversary of the assassination. Well, that's great. I'll be dead. I'm sure you'll still be living. I hope you'll come to my gravesite and yell loudly so I'll hear what's actually in there.
And my last question for you, do you think that this is going to lead to any more document releases in the future? Is there any kind of correlation there?
The 3,000 remaining documents, I think, are the heart of this, assuming they've all been turned over. And as I said, they could be lost and unretrievable or destroyed. We may never see those. But I think among these documents, you will still have some that won't be released because the CIA is going to object, and the FBI may object to some, and so on. And if you have those objections, generally the president goes along. Now, Trump may prove to be the exception to the rule. We'll see. We'll see. And he's got RFK Jr. Potentially in his cabinet. So he's going to be right there, undoubtedly, calling up President Trump and saying, can we get more documents released? So we all have to be patient. We've been incredibly patient for 61 years. We may have to be patient for a few more.
All right. Larry, thank you so much for taking the time to join us here and discuss this. Anything else you want to add before I let you go?
I would caution people against being too quick to accept conspiracy theories. Most of them are wrong because they're contradictory. They can't all be right. And in fact, none may be right. It's possible that we know the names of the assassins, and they're precisely the people who've been convicted of the assassinations. So don't get too cynical on account of this, but we ought to be skeptical, and we ought to insist that government be more transparent. You know, our tax dollars paid for all this stuff. And it's after all this time, we can't see much of this. I don't want to see Lee Harvey Oswald's tax returns. They're in there. You know, you're not allowed to release people's tax returns, even for the deceased. So some things, yes, it's legitimate to hold them back, but not very much.
All right. Larry, thank you again for taking the time to join us. We appreciate it.
Thank you very much. Enjoyed it.
All right, let's speak on that just a little bit. Robin?
You know, I remember all three of those assassinations. The whole country was paralyzed, deeply moved and paralyzed when JFK, John F. Kennedy, was shot. And I remember that day, November 22nd, 1963. I was 6 years old, I guess, and in school, and we heard the news, and I just remember those events and how profoundly it impacted everyone, and then there was a lot of turmoil. The 60s was a time of civil rights, and then Bobby Kennedy was very involved in the fight for civil rights, and we were all striving for a world where civil rights were defended and civil rights were protected, and it was not an easy battle. And when Bobby Kennedy got killed, that was another blow. And of course, Martin Luther King Jr., the great civil rights leader, had led protests all the way from Selma, Alabama, to Washington D.C. He had organized protests that had busloads of people, both black and white, that were for civil rights and wanted to change the laws and wanted to establish that civil rights belong to everyone equally, and that no one should be discriminated against on the basis of their skin color, and and so all of this was we were in a time of tremendous upheaval and tremendous turmoil, and of course the American people were rebelling against their own government for the war in Vietnam, and there were you know massive protests in all of the major cities, and I went to those with my mother, and while my father was working, we'd be at a protest and at a protest march, and this went on for years. Every few months, every couple of months, or every once in a while, we'd be at another protest, um, and so all of this has got a very personal resonance for me, and ever since those days, I have had a kind of a suspicion about who really was doing what to who, because it was clear to us who were fighting against the government that they were unscrupulous in their behavior against the people, and that they were willing to lie to people, and that they were willing to do to people. Well, there was Kent State where 4 students were killed in Ohio for protesting, and but with an overreactive police force that shot them dead. And so all of these events went on that led through the civil rights movement, um, that were very transformative in the history of America. And I was right there watching, and I was right there participating, very much integral to the process. And so, so I'm very curious as to what might be in those papers that would bring us more of the truth about what happened, because I don't believe those papers would have been suppressed if everything had been above board and honest. I
Right.
think we would already have that information if there had not been a suppression of the truth that went along with these events.
Well, one of my theories is that we're going to find out that Lyndon B. Johnson was heavily involved. Um, and so, and that's one of my, just from the research that and stuff that I've dug into a bit. But I also believe there's a connection to the UFO file as well. But I definitely think that I don't know if we're going to see that in these documents or not. Who knows? They'll probably cover that up if anything. But I definitely believe that we're going to see some evidence of Lyndon B. Johnson's involvement, just based on what I already know from what I've seen and just doing my history, my digging, and from watching others doing the same work. So that's my prediction there. Definitely.
Yeah, I've often looked at history and looked at the players involved, and surmised that there could very well be that connection that you're talking about. That, I mean, who stood to benefit the most? Well, Lyndon Johnson stood to benefit the most because he inherited the presidency of the United States, which he did not have the charisma to earn or win for himself.
Right. He had a motive. He definitely had a motive. That's for sure. Let's get into the next part. We're going to be going in. We're going to be going over the executive order signed by Trump on the 21st of this month, like 4 days ago, ending illegal discrimination and restoring merit-based opportunity. Now, this is the controversial one, as it rescinds executive order. Which one was it? 11246, which was an executive order known as the Equal Employment Opportunity. Now, we're going to, it's been argued that this, could open the door to potentially allowing federal contractors to discriminate based on race. However, the actual law, Civil Rights Act of 1964, Section, I believe, 7, is still in effect. So it's still against the federal law. It's still against federal law to discriminate in your employment practices. Just the executive order, from what I understand, was rescinded on that particular one. So we're going to get into that and go over a few different articles from both sides of the aisle and see what they say and get some perspective, and then talk about it. So let's start off with that. Ending illegal discrimination and restoring merit-based opportunity. By the authority vested in me as president by the Constitution and the laws of the United States of America, it is hereby ordered. Section 1. Purpose. Longstanding federal civil rights laws protect individual Americans from discrimination based on race, color, religion, sex, or national origin. These civil rights protections serve as a bedrock supporting equality of opportunity for all Americans. As president, I have a solemn duty to ensure that these laws are enforced for the benefit of all Americans. Yet today, roughly 60 years after the passage of the Civil Rights Act of 1964, critical and influential institutions of American society, including the federal government, major corporations, financial institutions, the medical industry, large commercial airlines, law enforcement agencies, and institutions of higher education have adopted and actively used dangerous, demeaning, and immoral race and sex-based preferences under the guise of so-called diversity, equity, and inclusion, otherwise known as DEI, or diversity, equity, inclusion, and accessibility, DEIA, that can violate the civil rights laws of this nation. Illegal DEI and DEIA policies not only violate the text and spirit of our longstanding federal civil rights, they also undermine our national unity as they deny, discredit, and undermine the traditional American values of hard work, excellence, and individual achievement in favor of an unlawful, corrosive, and pernicious identity-based spoils system. Hardworking Americans who deserve a shot at the American dream should not be stigmatized, demeaned, or shut out of opportunities because of their race or sex. These illegal DEI and DEIA policies also threaten the safety of American men, women, and children across the nation by diminishing the importance of individual merit, aptitude, and hard work and determination while selecting people for jobs and services in key sectors of American society, including all levels of government and the medical, aviation, and law enforcement communities. Yet, in case after tragic case, the American people have witnessed firsthand the disastrous consequences of illegal, pernicious discrimination that has prioritized how people were born instead of what they were capable of doing. The federal government is charged with enforcing our civil rights laws. The purpose of this order is to ensure that it does so by ending illegal preferences and discrimination. Section 2 policy. It is the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. I therefore order all executive departments and agencies to terminate all discriminatory and illegal preferences, mandate policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. I further order all agencies to enforce our longstanding civil rights laws and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. Section 3, terminating illegal discrimination in the federal government. The following executive actions are hereby revoked. Executive Order 12898 of February 11th, 1994. Federal actions to address environmental justice in minority populations and low-income populations. Executive Order 13583 on August 18th, 2011, establishing a coordinated government-wide initiative to promote diversity and inclusion in the federal workforce. Executive Order 13672, July 21st, 2014. Further amendments to Executive Order 11478. Equal opportunity employment in the federal government and Executive Order 11246. Equal employment opportunity, and the Presidential Memorandum of October 5th, 2016, promoting diversity and inclusion in the national security workforce. The federal contracting process shall be streamlined to enhance speed and efficiency, reduce costs, and require federal contractors and subcontractors to comply with our civil rights laws. Accordingly, Executive Order 11246 of September 24th, 1965, Equal Employment Opportunity, is hereby revoked. For 90 days from the date of this order, federal contractors may continue to comply with the regulatory scheme in effect on January 20th, 2025. The Office of Federal Contract Compliance programs within the Department of Labor shall immediately cease: A, promoting diversity; B, hiring or holding federal contractors and subcontractors responsible for taking affirmative action; and C, allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. In accordance with Executive Order 13279 of December 12, 2002, equal protection of the laws for faith-based community organizations, the employment, procurement, and contracting practices of federal contractors and subcontractors shall not consider race, color, sex, sexual preference, religion, or national origin in ways that violate the nation's civil rights laws. The head of each agency shall include in every contract or grant award a term requiring the contractual counterparty or grant receipt to agree that it is in compliance in all aspects with all applicable federal anti-discrimination laws, is material to the government's payment decisions for purposes of Section 3729B4 of Title 31 United States Code, and a term requiring such counterparty or recipient to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. The director of the Office of Management and Budget, OBN or OMB, with the assistance of the Attorney General as requested, shall 1. Review and revise as appropriate all government-wide processes, directives, and guidance. 2. Excise references to DEA and DEAI or DEIEA principles under whatever name they may appear from federal acquisition, contracting, grants, and financial assistance procedures to streamline those procedures. Improve speed and efficiency, lower costs, and comply with civil rights laws. And 3, terminate all diversity, equity, equitable decision-making, equitable employment, deployment of financial and technical assistance, advancing equity and like mandates, requirements, programs, or activities as appropriate. Section 4, encouraging the private sector to end illegal DEI discrimination preferences. The heads of all agencies, with the assistance of the Attorney General, shall take all appropriate action with respect to the operations or their agencies to advance in the private sector and the policy of individual initiative, excellence, and hard work identified in Section 2 of this order. B, to further inform and advise me so that my administration may formulate appropriate and effective civil rights policy, the Attorney General, within 120 days of this order, in consultation with the heads of relevant agencies and in coordination with the director of OMB, shall submit a report to the assistance to the President for domestic policy containing recommendations for enforcing civil rights laws and taking other appropriate measures to encourage the private sector to end illegal discrimination and preferences, including DEI. The report shall contain a proposed strategic enforcement plan identifying key sectors of concern within each agency's jurisdiction, the most egregious and discriminatory DEI practitioners in each sector of concern, a plan of specific steps or measures to deter DEI programs or principles, whether specifically denominated DEI or otherwise, that constitute illegal discrimination or preferences. As a part of this plan, each agency shall identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Other strategies to encourage private sector to end illegal DEI discrimination and preferences and comply with all federal civil rights laws. And it goes on a bit further, folks, but I'm not going to bore you with all the details, but the links are in the description. So we're going to look at this real quick. This is the memorandum, or just the order, the letter to the Department of Labor from the Trump administration to cease and desist all investigative and enforcement activities under rescinded Executive Order 11246. And so basically this Executive Order 11246, you want to go ahead and read this one, Robin? A little bit. Hold on, let me get it. I want to get down into, I want to read this, get some of this read, but I want to get into the rescinded part after this. Are you able to see it okay? No? Oh, you're muted.
It's a little small for me to be able to read.
All right, all right. How about that?
I think I can do that.
All right, here we go.
Executive Order 11-12-40.
46.
No, 11-246. See also Equal Employment Opportunity Act of 1972. Was an executive order, the Article 2 branch of the U.S. federal government, in place from 65 to 2025, specifying non-discriminatory practices and affirmative action in federal government hiring and employment. The executive action was signed by President Lyndon B. Johnson on September 24th, 1965, establishing requirements for non-discriminatory practices in hiring and employment on the part of U.S. government contractors. As amended, it prohibited federal contractors and subcontractors and federally assisted construction contractors and subcontractors that generally have contracts that exceed $10,000 from discriminating in employment decisions on the basis of race, color, religion, sex, or national origin. It also required contractors to take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. The phrase affirmative action had appeared previously on Executive Order 10925 in 1961. The executive order was rescinded by President Donald Trump on January 21st, 2025. Background. Executive Order 11246, EO 11246, followed up Executive Order 10479, signed by President Dwight D. Eisenhower on August 13th, 1953, which established the Anti-Discrimination Committee on Government Contracts, which was itself based on a similar Executive Order 8802 issued by President Franklin D. Roosevelt in 1941. Eisenhower's executive order has been amended and updated by at least 6 executive orders. It differed significantly from the requirements of the Civil Rights Act of 1964, which required organizations only to document their practices once there was a preliminary finding of wrongdoing. The executive order required the businesses that were covered to maintain and furnish documentation of hiring and employment practices upon request.
Oh, shit. Sorry about that. There we go.
The executive order, which also required contractors with 51 or more employees and contracts of 50,000 or more to implement affirmative action plans to increase the participation of minorities and women in the workplace if a workforce analysis demonstrates their underrepresentation, meaning that there are fewer minorities and women that would be than would be expected given the numbers of minorities and women qualified to hold the positions available. Apologies. Federal regulations require affirmative action plans to include an equal opportunity policy statement, an analysis of the current workforce, identification of underrepresented areas, the establishment of reasonable, flexible goals and timetables for increasing employment opportunities, specific action-oriented programs to address problem areas, support for community action programs, and the establishment of an internal audit and reporting system. It assigned the responsibility for enforcing parts of the non-discrimination in contracts with private industry to the Department of Labor. Detailed regulations for compliance with the order were not issued until 1969, when the Nixon administration made affirmative action part of its civil rights strategy. In 1971, a 3-judge panel of the United States Court of Appeals for the Third Circuit affirmed the validity of Executive Order 11246 in a case brought by the Contractors Association of Eastern Pennsylvania in January 1970 that challenged the Nixon administration's implementation, known as the Philadelphia Plan. In April 1971, the court rejected numerous challenges to the order, including claims that it was beyond the president's constitutional authority, was inconsistent with Title VI and VII of the Civil Rights Act of 1964, and was inconsistent with the National Labor Relations Act. The Supreme Court of the United States declined to hear the case, Contractors Association of Eastern Pennsylvania versus Secretary of Labor, in October. In 1986, the Reagan administration
Sorry about that. Hold on. There we go.
was opposed to the affirmative action requirements of the executive order and contemplated modifying it to prohibit their employees from using quotas, goals, or other numerical objectives, or any scheme, device, or technique that discriminates against or grants any preference to any person on the basis of race, color, religion, sex, or national origin. The contemplated change was never issued because it faced bipartisan opposition in Congress that threatened to counteract it by enacting Executive Order 11246 into law by a veto-proof majority.
I can read this part if you'd like.
Please.
Amendments. On October 13th, 1967, Executive Order 11375 amended Executive Order 11246, adding the category sex to the anti-discrimination provisions. On July 21st, 2014, Executive Order 13672 amended Executive Order 11246 and Executive Order 11478 to change sexual orientation to sexual orientation and gender identity. Revocation. On January 21st, 2025, President Donald Trump rescinded Executive Order 11246, originally signed by President Lyndon B. Johnson in 1965. The order had prohibited federal contractors from engaging in employment discrimination based on race, color, religion, sex, sexual orientation, gender identity, or national origin. It also mandated affirmative action programs to promote equal employment opportunities. The Trump administration characterized the rescission as a necessary step to eliminate radical and wasteful diversity, equity, and inclusion programs within the federal government and its contractors. It argued that the requirements under the executive order fostered preferential treatment and deviated from merit-based hiring practices. Effects. The Trump administration emphasized its commitment to merit-based hiring practices as part of its rationale for rescinding Executive Order 11246. Officials argued that employment decisions should prioritize an individual's qualification skills and job performance rather than demographic factors or affirmative action requirements. An executive order was issued alongside this initiative to mandate reforms in the federal hiring process, focusing on competency-based assessments and eliminating considerations tied to diversity, equity, and inclusion programs. Critics argued that this approach could result in reduced workplace diversity and fail to address systemic discrimination, while proponents contend that it ensured fairness and efficiency by focusing solely on individual merit. The rescission of Executive Order 11246 removed the obligation for federal contractors to establish affirmative action programs aimed at increasing workplace diversity. Civil rights advocates criticized the decision, arguing that it could undermine decades of progress in promoting equal employment opportunities and addressing systemic discrimination. And there is concern for that. And I myself was kind of concerned about that being a factor as well when I read this. But then I also read deeper that the following was what it said. Despite the revocation, protections against employment discrimination remain in place under Title VII of the Civil Rights Act of 1964. Title VII prohibits discrimination on the basis of race, color, religion, sex, and national origin in workplaces with 15 or more employees, including federal contractors. These provisions serve as the primary legal framework to combat employment discrimination in the United States. While the Civil Rights Act provides robust anti-discrimination protections, critics of the rescission argued that the lack of affirmative action requirements could result in fewer proactive measures to address inequities in hiring and workplace diversity. And I kind of agree with that statement a bit. It could. There's a possibility there if we don't watch, if we're not very careful and making sure this is implemented right. I absolutely get that. This is an article, and I was according to Wikipedia, and then we also have the actual Civil Rights Act that is still in effect. Goes all the way down here, and you guys can check it out on your time. It's way too much for us to read the whole thing, but there's a lot. Title VII right here, as you can see. All right, so we're just going to go on to this article over here by Reuters. This is a argument that's not in favor of the rescission, which we're going to go and read this point of view. And then we're going to read one more, which is a legal point of view from a law firm, Jackson Lewis. All right. Washington, 23rd of January, Reuters. When U.S. President Lyndon B. Johnson took the stage at Howard University in June of 1965, he had already signed the Civil Rights Act into law, and he said he expected to sign the Voting Rights Act shortly. The hard-fought legislation crafted after widespread protests and demonstrations by Black Americans was not enough, Johnson told Howard's historically Black university graduating class. He laid out the vast economic gulf between Black and white Americans and his plans to address it. Black poverty is not the same as white poverty, Johnson, a Democrat, said. It was also caused by ancient brutality, past injustice, and present prejudice. Black Americans are still buried under the blanket of history and circumstance. It is not a lasting solution to lift just one corner of that blanket. We must stand on all sides and we must brace the entire cover if we are to liberate our fellow citizens, he said. Rather than improving their situation, was declining by many measures, Johnson said. Black male income had declined and unemployment risen in recent years, he noted. The unemployment rate for black and white men was nearly equal 35 years ago, he said, but since then had become twice as high for black men than for white. The median income of black families dropped from 57% of what white households earned in 1952 to 53% in 1963, he said. Johnson said he was calling a conference of scholars, government officials, and black leaders to ensure that black Americans move beyond opportunity to achievement. In September, he signed Executive Order 11246, forbidding employment discrimination on the basis of race, color, religion, and national origin by organizations receiving federal contracting and required federal contractors to set up detailed affirmative action programs to make sure that that was the case that are monitored by the federal government. Trump rescinded the order late on Tuesday in a flurry of measures aimed at repealing diversity programs across the country in a move that could have far-reaching impacts. The White House included the order's elimination under a list of measures it called terminating illegal discrimination in the federal government. The rescinded order is the federal authority underpinning affirmative action for federal contractors and subcontractors law. Firm Duane Morris explained in a message to federal contractors. The executive order represents a radical change in government policy that throws the entire existence of race and gender-based affirmative action into limbo. The phrase affirmative action and much of the executive order Trump is repealing is built on one signed by Johnson's predecessor, John F. Kennedy, in March of 1961, which asked government contractors to take affirmative action to ensure employees and applicants were treated without regard to their race, creed, color, or national origin. Trump's rescinding of a 60-year-old order comes as the racial gap in median income has improved only slightly since LBJ's 1965 speech. The median income of white non-Hispanic families in 2023 was $89,050, according to the U.S. Census, while the median income of black households was $56,490, about 63% of white households. And then it says, get weekly news and analysis on U.S. politics and how it matters to sign up for Reuters newsletter, whatever. Anyway, so that's that article. And then we have a differing point of view that goes to, I think it does a better job of explaining, breaking it down, I think, in my view. And it's pretty, it clarifies a few things. So, so Trump administration revokes Executive Order 11246, prohibits illegal DEI, what the executive order ending illegal discrimination and restoring merit-based opportunity means for employers. This is dated January 23rd, 2025. Matthew J. Carmadella, K. Joy Chin, Michael R. Hatcher, Semia M. Kermani, Lisa B. Marsh, Laura A. Mitchell, and Michael D. Thomas. This is who this is by. Takeaways. The executive order does not change existing law, but it signals the administration's focus on targeting organizations that violate existing anti-discrimination laws in their employment practices. For federal contractors, it eliminates affirmative action plan obligations regarding race and gender, as had been required by Executive Order 11246 and enforcement activity by the OFCCP regarding race or gender affirmative action plans. For all employers, the executive order signals increased investigation and enforcement activities relating to DEI programs that utilize discriminatory preferences. And then it has related links. Ending illegal discrimination and restoring merit-based opportunity, executive order fact sheet. President Donald J. Trump protects civil rights and merit-based opportunity by ending illegal DEI at the White House. And new presidential executive order says federal government recognizes two sexes only, and that's links to unrelated, well, similarly related. Article. On January 21st, 2025, President Donald Trump issued an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunities. The executive order, its stated purpose is to end illegal diversity, equity, and inclusion, and diversity, equity, inclusion, and accessibility together. DEI. The executive order comes a day after President Trump signed the executive order on defending women from gender ideology, extremism, and restoring biological truth to the federal government, and a slew of other day one orders regarding DEI. The executive order instructs federal agencies to take specific actions to end illegal DEI in federal contracting. It also directs agencies to encourage private employers to eradicate illegal DEI. The executive order states it is the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. I therefore order all executive departments and agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. The executive order does not change existing law regarding discrimination in contracting, employment, or otherwise. Rather, it signals the administration's focus on targeting organizations that violate existing anti-discrimination laws in their employment practices. The key message, which is not necessarily new, employers should focus on ensuring their DEI practices comply with equal opportunity employment laws. What does the executive order say? 1. Federal contracting and revocation of Executive Order 11246. Section 3 of the executive order, entitled Terminating Illegal Discrimination in the Federal Government, focuses on federal contracting process and revokes a series of earlier executive orders and presidential memoranda, including Executive Order 11246, the primary executive order on federal contractor affirmative action obligations. Executive Order 11246, Equal Opportunity Employment, was issued in 1965 by President Lyndon Johnson. It prohibited employment discrimination by federal contractors and subcontractors and required contractors and subcontractors to take affirmative action to ensure equal employment opportunity. The new executive order bars federal contractors from considering race, color, sex, sexual preference, religion, or national origin in their employment, procurement, or contracting practices in ways that could violate the nation's civil rights laws. In addition, the executive order orders the Office of the Federal Contract Compliance Programs, OFCCP, to immediately cease promoting diversity, holding contractors and subcontractors responsible for taking affirmative action, allowing or encouraging workforce balancing based on race, color, sex, sexual preference, religion, or national origin. The executive order requires federal agencies to include specific terms in their contracts or grant awards that require contracting parties to, or grant recipients to comply with all applicable federal anti-discrimination laws and certify that they do not operate any illegal DEI programs. The order does not provide more detail on what this certification will entail. In addition, the executive order directs the director of the Office Management and Budget to remove all references to DEI principles from federal acquisition, contracting grants, and federal and financial assistance procedures. The executive order further prohibits mandates, requirements, programs, or activities that promote affirmative action, diversity, equity, and related practice, but does not define those terms. 2. Encouraging private sector to end illegal DEI discrimination and preferences. In addition to addressing federal contractors, the executive order also addresses private employer DEI activities. Title VII of the Civil Rights Act and other state federal anti-discrimination laws prohibit discrimination in employment and require equal employment opportunity. The executive order does not change that. In Section 4 of the executive order, entitled Encouraging the Private Sector to End Illegal DEI Discrimination and Preferences, the administration directs federal agencies in coordination with the Attorney General, newly appointed yet to be confirmed, Pamela Bondi, to take action to implement the principles of the executive order. Section 4 further requires that the Attorney General, in consultation with the agency heads, to submit a report within 120 days of identifying key sectors of concern, egregious and discriminatory practitioners, and a plan to deter DEI programs or principles that constitute illegal discrimination or preferences. As part of that plan, each agency is to identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations, or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments of over $1 billion. They are also to identify other strategies that to encourage the private sector to end illegal DEI discrimination and preferences and appropriate potential litigation for the administration to pursue. Do you feel like reading this last part? Or no? All right, I'll read it. What the EO means for federal contractors. For federal contractors, the executive order's main takeaways are as follows. The executive order does not eliminate the OFCCP as an agency or take away any contractor non-discrimination obligations. The executive order eliminates federal contractor affirmative action plan obligations regarding race, gender, and have been required by Executive Order 11246 and enforcement activity by the OFCCP regarding race or gender affirmative action plans. The executive order does not impact obligations under VEVRAA or Section 503, which are both statutes, not executive orders. For now, OFCCP retains jurisdiction over ensuring contractors comply with these laws. Contractors should review any currently pending OFCCP request to determine whether the information requested stems from Executive Order 11246. Contractors should continue to prepare VEVRAA and Section 503 affirmative action plans. Additionally, the executive order calls for the development of a new contract term, presumably a replacement for the current equal employment opportunity clause for inclusion in federal contracts, which will require contractors to agree that compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for purposes of Section 3729B4 of Title 31 United States Code. The executive order requires contractors to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. The White House fact sheet accompanying the executive order notes this certification will be an unmistakable affirmation that contractors will not engage in illegal discrimination, including illegal DEI. Review any new government contracts for new relevant executive orders or DEI terms. What the executive order means for all contractor and non-contractor employers. For all employers, whether they are federal contractors, the executive order does not change the law relating to employment discrimination. It does, however, signal increased investigation and enforcement activities relating to DEI programs that utilize discriminatory preferences. Employers should consider taking the following actions. Review employment practices and DEI initiatives for compliance with non-discrimination statutes, such as Title VII of the Civil Rights Act of 1964. Eliminate or revise policies or practices that are likely inconsistent with existing law. Review executive order policies, review EEO policies and communications to assess the risk of enforcement agency investigations. Reassure employees of the employer's commitment to equal employment opportunity and non-discrimination. Focus on employee psychological safety and wellness, and stay tuned for challenges to the executive order and more information about sectors, industries, and organizations the federal agencies identify for investigation and further scrutiny and guidance from the Attorney General, Secretary of Education, and other federal agencies. We will continue to monitor developments. Please reach out to your Jackson Lewis attorney, yada, yada, yada. So that's what its recommendation is for employers, this article. So let's talk about it for a bit. You want to unmute yourself, Robin?
Yeah.
Oh, you already did. My bad. Do it again. Sorry. You did it right as I clicked ask to unmute, and then it remuted you.
Okay. Yeah, this, this is one of the things that the American people have been looking at that I think was a sticking point for a lot of people, was that in the effort not to discriminate, our society has gone so far towards trying to promote non-discrimination that it is now discriminating. It has created whole areas of our economy where it's as long as you're one of those people that it's okay to discriminate against, fine, discriminate all you want. Those people, tough luck for them. They should be discriminated against, because I think we all recognize that's guys like me, old white guys, are now a target that is an open season target. Everyone is allowed to take pot shots at old white guys because they're considered to be the epitome of white privilege, the epitome of a male-dominated culture. And so it's perfectly all right if you want to discriminate against those people, because they've already got too much privilege. They got way too much privilege in society. That's kind of the perception and idea under which our society is functioning now. However, because that's the prevailing gestalt of the people looking around, they see the society and they say, well, yeah, that's just reality. It has become perfectly acceptable to discriminate against those individuals. And that's exactly what has happened. Now, those people find it almost impossible to find work, to find jobs, to get equal pay for equal work. They are the most discriminated against in society. And the problem is that if you have any group that it is okay to discriminate against because they are the flavor du jour that society is blaming all its problems on, then you've created a culture that makes it possible to then discriminate with impunity. That you can then say, well, they're the ones who deserve to be discriminated against. But if I were to say to you, well, let's pretend that it's not old white guys. Let's pretend that it's young Jewish mothers. And then is it okay?
No,
No.
it's
Well,
not
okay.
okay in any form or
Then let's
fashion.
pretend that it's Indian members of society, people from the Indian culture. Then is it okay?
Nope.
No. Well, what about American Indian people? No,
No.
no. What about black people? Is it okay to
No.
Heavens, no. What what about Christians, specifically Christians? Well, kinda, sorta. Yeah, because they're also the privileged class. Sure, yeah. Okay. So, but
The
what you
minute you do that that's still racism. One
yeah,
way, no matter
exactly.
what way you cut it, and it's a violation of
Exactly
civil
my
rights laws.
that you still are you're still setting up a society where one group in society becomes the scapegoat for all the problems of that society. And then you are okay to say with the Tutsis that the Hutus are the problem, or with the Hutus that the Tutsis are the problem. And then you have a society where one day they all rise up and start chopping each other with machetes because, oh, well, they're the problem, so it's okay to cut them down. You have Germany in World War II, where it was okay to attack the intellectuals. It was okay to attack the Jews. It was okay to attack certain groups because, well, they're the troublemakers in society. They're the problem. Um, if you are the European coming to America for the first time, and you look around and you go, well, there's all these Native Americans in our way. Well, lucky for us that they're not as significant or as important to our society as you or I are. So it's okay to take them out. It's okay to just
The minute, the
kill
minute,
them.
the minute that you begin to justifying devaluation of human life is the minute you go down that slippery slope into becoming that which you were trying to fight against.
Right, right. And that is really the point that I'm making. That in all of our efforts, I believe that what we're doing in this moment in our culture is a necessary correction because we have what we've done is just labeled the ones that it's okay to discriminate against, and now we're all comfortable with those labels, and so now we're discriminating, but it's all okay with a great many people because we're discriminating against the right ones. We've got the bad guys this time, but that's always wrong. And that's always, you are the bad guys. The minute you say, oh, it's those people there, we need to eliminate them and then we'll have no more problems as a society. That's always wrong. That's always discrimination. It's always a form of racism, sexism, religionism. It's an ism that our society needs to do without. And so I'm grateful to see that these corrections are happening and concerned lest excuse me, the pendulum of public opinion swing too far to the other side, and we have real discrimination happening in the other direction. And, people really do have a hard time getting a job that are of some other group because now we're trying to correct the wrongdoing. So I think we have to guard against that, but I think we're moving in a way that is intelligent as a society to improve our culture and our society. And I'm grateful to see it for one.
Yeah, I'm glad we went over all those articles because I was needing more clarification on that specific executive order that he signed that rescinded the other one because I was like, wait a minute. But then upon further examination, we see, okay, yeah, the Civil Rights Act, Title VII, and all that's still in place. So that's good clarification to have because on the surface, it looks like, oh no, what's he doing? If you're not if you don't have the context of what's going on there. So that I'm grateful for that clarification. Um, Also, we have one more article according to the Department of Education, and this is as of yesterday. This is another big one. I'm not sure how to take this, but we're just going to let the screen reader read it for you guys, and then go from there, and then we'll wrap up talk about it a little bit, and then wrap up the show. That way, you and me don't have to do any reading right now. We'll let the computer do it.
The U.S. Department of Education's Office for Civil Rights, OCR, today announced that it has dismissed 11 complaints related to so-called book bans. The complaints alleged that local school districts' removal of age-inappropriate, sexually explicit, or obscene materials from their school libraries created a hostile environment for students, a meritless claim premised upon a dubious legal theory. Effective January 24, 2025, OCR has rescinded all department guidance issued under the theory that a school district's removal of age-inappropriate books from its libraries may violate civil rights laws. OCR is also dismissing 6 additional pending allegations of book banning and will no longer employ a book ban coordinator to investigate local school districts and parents working to protect students from obscene content. By dismissing these complaints and eliminating the position and authorities of a so-called book ban coordinator, the department is beginning the process of restoring the fundamental rights of parents to direct their children's education, said Acting Assistant Secretary for Civil Rights Craig Traynor. The department adheres to the deeply rooted American principle that local control over public education best allows parents and teachers alike to assess the educational needs of their children and communities. Parents and school boards have broad discretion to fulfill that important responsibility. These decisions will no longer be second-guessed by the Office for Civil Rights at the U.S. Department of Education. On January 20, 2025, incoming OCR leadership initiated a review of alleged book banning cases pending at the department. Attorneys quickly confirmed that books are not being banned, but that school districts, in consultation with parents and community stakeholders, have established common-sense processes by which to evaluate and remove age-inappropriate materials. Because this is a question of parental and community judgment, not civil rights, OCR has no role in these matters. Background: in June 2023, then President Biden announced that he would appoint a book ban coordinator within OCR. The coordinator's responsibilities included developing guidance and training to deter schools from limiting student access to sexually graphic or racially divisive books by claiming that these efforts may contribute to a hostile environment that may violate students' civil rights. Because the prior administration amplified this false narrative, OCR received 17 complaints alleging that school districts engaged in book banning. Additionally, incoming Trump administration OCR attorneys discovered that the first complaint to advance the book ban hoax was filed with OCR on February 23, 2022, against Forsyth County School District in Georgia. The complainant alleged that the district violated Title IX and Title VI by removing 8 books from the school library because they contained sexually explicit content. OCR's regional Atlanta office sought to dismiss the complaint in full, concluding that the complainant's allegations failed to state a violation of Title IX or Title VI. Biden-Harris administration appointed OCR leadership in Washington, D.C., however, overruled the nonpartisan, career employee determination that the complaint had no merit and extracted a resolution agreement from the district under threat of further federal intervention. This included requiring the district to post a statement in all of its middle and high schools that embraced diversity, equity, and inclusion and encouraged students to make Title IX and Title VI complaints. The department will terminate the agreement and any obligations under it.
Okay, so that was interesting. Go ahead, Robin, put in your 2 cents, and then I'll chime in a little bit, and then we'll wrap it up.
Well, I think it's a strange time. To me, it's almost as though our country is waking up from an odd dream, where we had this focus an idea that that there was something right and good about exposing young children to sexually explicit material. And I've always felt that that was an absurd thing to do and a wrong thing to do.
Yeah, I was just going to say, which of course is wrong.
Yeah. And so, but there was a certain segment of society that sort of was like, hey, look, we don't want people of diverse sexual orientations to feel alienated um, or minimized or not properly, I don't know, thought of in society. So we want to include them, and diversity, equity, and inclusion was kind of this idea that, well, so we have to encourage even the youngest of our children to be exposed to these odd, uh, what once was called perverse ideas of sexuality, um, so that so that we're supporting them somehow. And to me, that's not support at all. To me, that's really a form of child abuse. These children who are too young to have what an adolescent has, which is actual, real sexual urges, I think have no business being exposed to literature and images that would foster those urges and that feeds into that mindset. They're too immature, and I felt that it was, we're making a mistake by allowing those things. But there were those that were lobbying the schools for it, and there were, battles in school boards and battles in schools about what would be included in our schools. And I think the American people have, one of the things that was one of the things that was sort of on the ballot in the last election was, how are we going to handle this particular problem? And I think that the answer was, hey, look, leave the kids out of it. For the vast majority of people, there are still those that hold diverse views. Everyone's entitled to their own opinion, but to enforce those opinions on innocent children um, is to corrupt them, and to corrupt innocent children is absolutely wrong in my estimation.
So the way I took that article, I basically, the way I that came across to me was like Department of Education admitting that they were coerced by the Biden administration. I mean, that's how kind of how that came across to me just from reading that alone. Of course, we should always take everything with a grain of salt and use discernment as always. But I mean, that was pretty telling to me. Do you buy it? You think? I mean, it makes sense to me. I think if that was how it went down, why there was such an issue about it. Why it was because there was division being stoked by the administration
Well,
for
there was
reversing, ignoring their the local areas ruling. That there was no claim. Go ahead.
Yeah, I think there was no dearth of there was no lacking of coercion by the government in the Biden administration. And it had everything to do with I mean, they had their fingers in everything. They were um, telling people how they needed to think, what they needed to think, um, about everything, including their own personal health care, their education, um, what jobs, the discrimination on the job, and who you had to hire, how you had to use the terms male and female, who you were allowed to speak to in what words, with what pronouns. All of these things became these hot button issues. And so I think you're probably correct. I think that the Department of Education was sort of feeling the thumbprint of a overlord trying to push an agenda on them. And it does sort of look like they're expressing a little relief at not having to be under the thumb of those tyrants.
Yeah, definitely, I agree. It's quite telling. I mean, just the demeanor of it. It seems like, I mean, because I mean, shit. How would anybody know? I mean, like, like until we know, it's just like I would never imagine that. I don't think many people would have imagined that our own government would be doing that. Pushing a narrative even against the ruling of the OCR office, the locally where that occurred, where some of that first issue occurred. Like, and they were pushing a false narrative, and people should be pissed about that. I know I am.
Yep.
And everybody should be that we were pitted against each other. I think that was really fucked up of the Biden administration to do that.
Yeah. Yeah, it really begs the question, um, who and what was the real motivation behind?
Yeah, definitely.
Because I don't think Joe Biden had that big of an axe to grind. I think that Joe Biden
Was
was
having his strings pulled,
a tool of those who were manipulating society into a particular direction for their own ends.
namely the top 1% of the top 1% of the top 1%, the men who play God without permission.
Yeah, yeah, the Soros-backed billionaire
Exactly.
club. Basically, this is what it boils down to.
Yep.
Uh, and and their agenda has always been to own everybody and everything. People are another resource on the earth. They own enough of the resources on the earth till they really want all of it. They want complete control. And this is Davos, Switzerland meetings. This is the World Health Organization. This is the World Economic Forum. All of these groups,
You will eat sea bugs.
and like I said, and
You
do
will
it
know nothing
own
and be
nothing
happy.
and be happy.
Fuck you, Klaus Schwab. Fuck you, motherfucker.
Yeah,
Not on my watch.
no, that's not a free society.
No,
And as an American, my whole life, I don't want to give up my freedom.
nor do I. And nor should any American.
No, but you do have to fight for it.
Yeah.
And it's just the fact of the matter. People are delighted to take your freedom. They're delighted to take the power that you're going to abdicate to them. If you'll allow them to have it, they'll run your world for you. And so we just can't do that. We have to maintain control of our world and our life, and maintain control of our lives, and our culture is the way that we maintain control of our world. And it's our world. It doesn't belong to billionaires. It belongs to itself. It's its own being. And we're shepherds in this field, looking out for all of the creatures. And if we don't do a good job, then we've got people willing to do a very, very bad job and just control it for their own benefit. And we can't allow it.
Well said. Well said. I agree 100% on that. We have to be very vigilant. And every one of us, each one of us citizens has to do our due diligence and call shit out if we think there's something wrong or something not being done right. It's up to we, the people, to voice our concerns and put pressure on government when it's not acting right, and encourage proper and ethical behavior in our federal government when it is doing good. We need to be.
That's right.
We have to be the stewards of that duty, folks.
That's right. And that means we laud them when we find them doing right, and we curse them loudly when we find them doing wrong.
Exactly.
And
regardless of the side of the political aisle it's coming from, because we know there's corruption on both sides either way.
Oh yeah.
We can't generalize and say, oh, this one side's bad or that one side's bad. We have to do it on a case by case basis, I think.
Right. What we can look at is say, well, this set of actions leading to this outcome. Well, in my book, that's really horrible. So I'm against the individuals promoting this set of actions. And their actions are something I feel we need to stop. And so I will stand up and speak out about those things.
Exactly. Exactly. Thank you, everybody, for joining us. Thank you, Robin, for joining us as well. I had been wanting to report on Monday, but everybody was sick, so we just we opted to postpone until everybody was feeling better. So
I apologize. I still have some residual effects, but I'm on the mend now.
he's work ready. He's work ready. He did a show tonight, so he's work ready. That's what I call it, work ready. Not quite 100%, but well enough to work.
Yeah.
And you did a great job, by the way. Even with your raspy voice, you did great.
Well, I appreciate you, Stephen. It's always a privilege to work with you.
Thank you. Thank you. Good night, everyone. Thank you for joining us. We'll be back soon.
Good night, all.